5 seconds to go. Start. Learned counsel would elaborate that it had not been the case of the plaintiff respondent number 1 that the trial court failed to consider any evidence adduced by her, or that she could not produce any vital piece of evidence for any valid reason. Stop. On the contrary, she neither got examined itself nor examined the sub-registrar, who had registered the sale deed, and rather, the plaintiff's husband, who was an attesting witness to the earlier agreement for sale, was examined in evidence on her behalf as PW1. Stop. With reference to illustration G to section 114 of the Evidence Act, learned counsel for the appellant has argued that adverse inference ought to have been drawn against the plaintiff respondent number 1 for not presenting herself in the witness box, particularly when the allegations of fraud were sought to be made the basis of her claim. Stop. Learned counsel has also submitted that none of the elements of Proviso 1 to Section 92 of the Evidence Act having been established, the trial court, after appreciation of evidence, took a reasonable view of the matter while finding that the circumstances were probabilizing the case of the defendant appellant. Stop. Hence, for the suit having rightly been dismissed, there was no reason to remand the case for a trial de novo. Stop. Learned counsel has referred to and relied upon the decision of this court in the case of Municipal Corporation, Hyderabad versus Sundar Singh, 2008, 8 SCC 485. Stop. Para. Per contra, with reference to the background aspects, the learned counsel for the plaintiff respondent number 1 has vehemently argued that the sale deed in question is a void document as no consideration was passed on to her, and hence, the same is liable to be set aside. Stop. According to the learned counsel, when the appellate court came to the conclusion that necessary evidence for proper determination of suit had not been brought on record, it had wide and ample powers to even suo motu remand the matter to the trial court, and the High Court cannot be faulted in adopting this course in the present matter for securing the ends of justice. Stop. Learned counsel has referred to the provisions contained in Rules 23, 23A, 24, 27 1B and 33 of Order 41 of the Code of Civil Procedure, 1908 to submit that the High Court has rightly remanded the matter after coming to the conclusion that the evidence on record was insufficient to arrive at a proper finding in favor of or against the sale deed. Stop. It has also been submitted that as per section 120 of the Evidence Act, husband of the plaintiff respondent number 1 was a competent witness as he was the manager of the theatre and was having knowledge about all the affairs of the theatre, and hence, it was entirely immaterial that the plaintiff respondent number 1 did not enter the witness box. Stop. Learned counsel has reiterated the stand of the plaintiff that she was made to sign on the sale deed. Stop.